Yes, counsel. Good morning.
Good morning, Chief Justice Ireland, and may it please the Court. My name is Robert Shaw. It's my privilege to appear today on behalf of Solange Anestal. My intention this morning is to focus on certain core fundamental aspects of the issues raised. And the first of those issues concerns the prosecutor's persistent and repetitive focus on allegations that Ms. Anestal abused a young child. And I would suggest to the Court that despite the effort I've made to try to convey the ongoing and aggregating focus on these allegations, it really is very important for the Court to look through the entire transcript to see the way this trial evolved and to see the way this issue evolved in that larger context. And I think that when the Court does that, the Court will come away with the same impression that I was left with, which is that this was improper, that this was overreaching, and that this was unjustified. Now, the Commonwealth on appeal has an explanation for this, and I'd like to look at that, and very importantly, how the Commonwealth gets there, because we say, on the one hand, that the defense in this case was about Ms. Anestal's state of mind and her perception on the night in question, and necessarily about a diagnosis of PTSD, which was explanatory of that state of mind when this incident occurred. The Commonwealth, on the other hand, is trying to redefine the defense very broadly as a means to counter the defense on appeal and justify what the prosecutors did. And according to the Commonwealth, this was about Ms. Anestal's character, her character of being nothing but a long-suffering victim. It was about her history generally, and therefore they say that the prosecutors were entitled to look at any aspect of her history and attack her character. And I say that that is both wrong factually and it's wrong on the law.
Mr. Shaw, could I just ask you it's a factual question, but when the expert witnesses were testifying, and I guess particularly the nurse, Burgess, about Ms. Anestal's history, defendant's history, and did anybody ask for a limiting instruction? That is, this is only coming in not for its truth, but because it is the basis of the opinion of the expert?
I don't believe so.
Prosecution didn't either.
I don't believe so, no. And I think that when the Court looks at the nature of this case, what you will see is that there was no efficacy to characterizing Ms. Anestal as nothing but a long-suffering victim, because this was about a medical diagnosis, post-traumatic stress disorder, and what happened on the night in question. And if Ms. Anestal was trying to put forward her character, she would have been limited to doing so with reputation evidence and opinion evidence. That's well established in our jurisdiction here. And further, the notion that because the defense focused on Mr. Petitry and focused upon their relationship, that does not open the door to attacking Ms. Anestal's character, because what that was relevant to was the effect it had on her state of mind. And that is true even in the more liberal context of the federal rules of evidence in 404. If you look to the 2000 amendment and the notes of the advisory committee on the 2000 amendment, what you will see is that they make explicit reference to the fact that when evidence of a victim is brought forward because of the effect it has on a defendant's state of mind, that does not open the door, even in that more liberal context, to attacking the character of the defendant.
Now help me to understand where you say the judge abused his discretion. The judge moved in various steps, one of which was to allow the jury to know that the allegations of abuse were made against her and not against the victim. Are you saying the judge abused his discretion in allowing that in?
I think that, as I indicate in my briefs, I think that the judge, given the way this unfolded, would have been within his discretion to permit the jury to understand that there was a claim against Ms. Anestal relative to DSS. And then what he should have done is he should have provided a limiting instruction, which simply said, don't speculate. They knew this, but this continued on and on and on and on until you get up to volume 6, pages 180 through 188, where there was this culmination, bringing out these allegations again, what happened to the child, being removed from the home, foster care, and all these other things.
Didn't he get? I thought he did give a limiting instruction about you can't hold. She's just not a bad person. It doesn't mean she would murder, et cetera, et cetera.
I believe there was 1 or 2 limiting instructions, but this is after all of this has come out. I mean, this has come out 5 times at this point. So there should have been an initial limiting instruction, and that's what he suggested would have solved the problem initially. And it is troubling to me as someone who works on the defense side, because judges provide limiting instructions, and we live with them very, very often in these cases. But initially, when this was starting to unfold, that wasn't good enough for the prosecution because it was their witness. But then now on appeal, after all of this very inflammatory, damaging information has come in, what do they do to turn to justify it? They say, well, there was a limiting instruction, no harm, no foul. Now, I think it's important to note also that the Commonwealth had a lot of opportunity to respond to the defense in this case. They could have challenged the events on the night in question. They could have challenged the nature of the relationship between Ms. Anestal and Mr. Petitry. They could have challenged the medical diagnosis and the effects if they felt that it wasn't.
I mean, but they had their own. They did challenge those things, right?
That's right, but that's sufficient, is my point. They didn't need to jump into these very damaging and inflammatory and irrelevant allegations. And I do say irrelevant because the fact that a young mother who's being bounced around homeless shelter to shelter with a hyperactive young boy may have at some point, we don't know, lost her temper with him, which someone witnessed, does not mean that she's a bad person, and it doesn't mean that she's more likely to commit homicide. But that's exactly what it appears the prosecution was trying to convey here. Now, moving on to the second bedroom door issue. The court has extensive material before it in our opening brief and record appendix. Today, I just want to emphasize relevance and materiality, and I would point to page 39, note 16 of our opening brief, which reviews a lot that's in the record. And I want to point out that the fact that there was a stress flight reaction in Ms. Anestal does not in any way preclude her ability to have used an operable second door if that second door had in fact been operable. That's just not supported by the record. That's not supported by expert testimony. The experts testified, and the evidence was that she was afraid. She picked up a piece of glass from a shattered window to protect herself, and she felt she needed to get out of the room, and she did get out of the room. So she had there been an operable second bedroom door, she could have used that door.
I'm sorry, she could have used which door?
The second bedroom door.
The one leading to the hallway.
Which led out of the apartment.
Okay.
Right.
But what do we do with the fact that we don't know whether that door was barred or not?
You certainly know now that it was barred.
Well, I gather the testimony came from the landlord, who was 4 or 5 years later. I mean, we don't have the landlord at the time. I mean, I'm not quite, and I gather there was no evidentiary hearing on that issue for the motion for new trial.
That was denied.
And at the time, I guess the evidence was ambiguous from the video and from the photograph. So what do we do with ambiguous evidence which you argue, I mean, you say now you think, based on this evidence, that it was indeed barred?
Oh, Your Honor, I would suggest to the court that there's no doubt that it was barred. The property owner who submitted an affidavit said that it's been that way from the day he bought it. Ms. Anestal filed
Was he the owner at the time of
not at the time of this incident, but he was saying that he never changed it, and that's I think he bought it some months after this incident. I think it's in the record. Ms. Anestal filed an affidavit. Her young niece filed an affidavit. her sister filed an affidavit. You've got photographs, okay? And defense counsel was indicating through his language on the record that he was aware that that door was sealed. And there is testimony that Ms. Anestal was saying during the course of this trial that that door was sealed. So I think it's very clear that that door was sealed.
But accepting that it was sealed, you still, I mean, you've got the facts of her coming out of the door saying, I think, or, you know, there's evidence, I'm going to kill you, I'm going to kill you, and sort of headed straight out. So, I mean, I guess I'm wondering how realistic would it have been to argue she would have gone out the other door, since one could view this as she was going after him. Now, it may have been because of a PTSD reaction. I'm not arguing about that, but the fact was she was going after him.
Well, I think that this evidence about this notion that she said, I'm going to kill you, you have to look at all of that testimony, because there was a lot of conflicting information coming in about that. Mr. Faoli was testifying about that. I think there's some difficulty in his testimony because it appears that English is his second language. But he went on to say and admit that initially, years earlier, what he had said and testified before the grand jury, I believe, is that he heard that from inside the room, the bedroom, okay? And it also came out that, in fact, this was being said in Creole. It wasn't being said in English. So I think there's some issue there. But I think that she told the police that she picked up the glass because she was afraid, and he had been hitting her. I also think that, you know, clearly it's relevant in the context of the trial because the prosecutors focused on it to rebut the defense. And the prosecutors focused on it in order to try to establish that Ms. Anestal was going out with the intent to harm. With respect to the self-defense instruction, I would suggest to the court that in this context, the analysis needs to begin with the fact that apprehension, and whether that apprehension is reasonable, really has to be looked at through the lens of an abusive history, being battered, and expert testimony on that subject. This is required through Chapter 233, Section 23F. And so my
Wait, you say that, but that chapter only says the evidence is admissible.
Right.
It doesn't say that the objective prong of self-defense is hereby being legislatively eliminated for those who have a history of abuse.
Well, Your Honor, if it is relevant evidence on the issue of self-defense and must be permitted in and considered by the jury, then it follows that when the judge is considering whether there is adequate evidence of self-defense, it must also be considered. I mean, I don't see how you could divorce the two.
Well, I mean, here's the problem. I mean, I understand your point, but the general instruction is that evidence of mental impairment may be considered in determining whether the defendant actually believed that she was in imminent danger of serious bodily harm or death, but not in determining whether a reasonable person in those circumstances would have believed that she was in imminent danger. So mental impairment can't be considered. You're saying that we need to interpret this statute to say that there's an exception for abused women?
Well, I think that
Or abused persons, I should say.
I think that the judgment of the legislature is that, you know, it is well established that people who have been subjected to abuse and battering, that we want as a policy matter to acknowledge how their perception is going to change as a result of that. It's not saying that the objective standard in self-defense is going to be thrown out. What it's saying is that when you make an objective evaluation, that you have to incorporate and take into account that there has been an abusive history here. So just like in the subsequent issue, it's much like saying it's a question of reasonableness, but it's reasonableness given the history of abuse.
Now, a history of abuse with this particular victim or a history of abuse in general?
Well, I mean, I think most of the time it's going to be a particular victim, but here clearly there was a long history of rather severe abuse, and if you look at the policy and the reasons for the law, it makes sense that it involves abuse generally, because ultimately what we're talking about is what is her perception at the time? What is her state of mind at the time? And if that past severe abuse affects that perception, then it's very important that that also be a part of it.
But even if you were to take that into account, she's in the room, he's left the room. Even if the jury were to take into account the entire history of his conduct, which I guess is very limited in the record. We have the former attorney testifying, but I gather there's nothing in the record indicate that he had struck her?
Well, there's, for example, first of all, she says to the police that he was hitting her, but there is in the record a prior incident within a short period of time
with the
before
attorney
that.
in the courthouse, I gather.
I'm sorry?
Oh, the one in the courthouse you're referring to?
Well, there's that as well, where he threatened to kill her, and somebody actually witnessed that, and he was extremely aggressive. But there's also an earlier incident where she's calling the police, and she's trying to get him to leave because he's intoxicated. He was twice the legal limit of intoxication when this occurred. So, but she didn't testify, and you know, I'm not going to go outside of the record, but she didn't testify. But, you know, the defense is that this was an abusive relationship and that she had had prior very abusive relationships, which was well established.
But you still have the fact that she was in the room, he had left, there were others in the apartment. Why would that permit an objective belief that she was in imminent danger of severe bodily harm or death?
Well, the defense is that she ran out of the room. She picked up the glass to ensure her protection. She ran out of the room, and then she didn't see anyone there, and then she was surprised by the fact that he, as I understand the facts, he was standing right there behind the door. Now, do I believe that Mr. Petitry would have just stood there and did nothing and she stabbed him? No, I don't believe that. I believe that he probably moved toward her at that point. There had just been violence and a violent struggle. But, you know, one could infer that. But even if one doesn't infer that, it was at that point that she reacted. And the testimony was that she was shocked to see him there. So at that point, she would have reacted in self-defense. Now, I want to be sure I can get to the 33E aspect of this. And I would suggest to the court that even if the court takes the position that I am wrong on every legal issue that I've placed before you, the fact remains, I think, that this incident arose out of highly charged circumstances. Even if you assume that Miss Anestal ran out of that bedroom with intent, the fact is that that intent arose out of heat of passion, overwhelming emotion that had already permeated those circumstances. And I want to ask the court to acknowledge, I mean, this is a young mother of two. She was confronted with violence on the night in question by a large man. He was twice the legal limit of intoxication. The weapon that she picked up had spontaneously appeared because a window had been shattered in an episode of violence. She acquired that weapon in the course of that violence that was filled with overwhelming emotion. And you have really what is extraordinary evidence here that she did not have a plan or intent. And you have that because there was a third party who saw what happened, and that third party, who was a lay person with English as a second language, described her as being shocked the moment she realized that he had been seriously injured. Now, how does somebody who is shocked consciously carrying out a plan and the intent to kill? And in addition to that, I mean, you have her reaction immediately, which is to try to save him, to try to help him. She was overcome with enormous and immense grief and distress the instant that this happened. And that reflects the fact that she was not killing in cold blood. So I understand that this court's power is rarely exercised in this area. But, you know, if these circumstances evidence killing in cold blood, then I think we really do have a problem with the concepts of deliberation and premeditation having been watered down. And I think this is an appropriate case for this court to exercise its power, and I would ask the court to find that a verdict of voluntary manslaughter is more consonant with justice. Thank you.
Thank you. Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Attorney Sharon Donatelli, one of the Commonwealth's trial attorneys, appears with me at counsel table. Your Honors, taking the issues in the order presented by the defense, the Commonwealth did not present or suggest that any particular character evidence of the defendant made her prone to commit murder. What happened here was that there was the defense from the very beginning of the trial presented the theory and supported it with expert testimony that the defendant's history of being abused, coupled with the victim's character as what they called a controlling abusive batterer, caused the defendant to react on the night of the killing because of feelings of overwhelming stress and abuse. It was the defense that brought the nature that of those characters, the nature of the history and the nature of the character into the evidence. The Commonwealth was then well within its rights, as the judge recognized as the case went on, then to present points from that very same history that cut against the conclusions drawn by the defense and the expert, that called the credibility of the expert opinion and the defense theory into question.
Could you just explain how the evidence regarding the defendant striking her son undermined or countered the expert's opinion?
Yes, Your Honor. First, from the very beginning, the defense called the defendant from the very opening a sick, drunken, uncaring, possessive batterer, and they particularly focused on the fact that, as they said, he was trying to obtain custody of the children. They brought the nature of that issue of custody over the children again and again into focus, including
that he was trying to get custody of both
that he
children?
was trying to get custody of the children.
Both children?
Both children, Your Honor.
The one that wasn't his as well?
Yes, Your Honor. And the expert Burgess called the victim a abusive, controlling man. She characterized the victim as compliant, who just went along with everything. She focused in particular on his attempts to gain custody of the children, and that somehow created additional stress for the victim. She relied on the history. I mean, that in itself opened the door to, as with Attorney Lawton's testimony, as the others, the dispute over the children's custody was very much in front of the jury. They attempted to use that to fortify their representation of the victim as an abusive batterer.
But I'm still not seeing how it is that her striking her son
Because-
undermined the expert's opinion.
Because, Your Honor, it undermines the characterization that she gave of the victim as the controlling abusive batterer, Your Honor.
It couldn't have been both? I mean,
The focus of the defense through much of this was on the nature of the custody issue of the children and DSS involvement and the arguments that they were having over the DSS involvement. As the judge recognized from the very beginning, not only from the defense attorney at trial, but also from Burgess, they tried to suggest that the issue involving custody of the children was somehow attributable to the manipulative, controlling nature of the victim, and that added to his stress. To put that for the jury in reasonable context, the jury quite appropriately, was allowed to hear that the nature of that DSS custody had nothing to do with the victim. It had to do with clear indications that the victim had been abusive to her children. Not only that, more broadly, Your Honor, which would include the prior incidents here, two aspects. One, the nature of the doctor's opinion was that her reaction at that time of the killing was necessarily attributable to this abusive history. This is one indication of incidents of highly inappropriate violence that had nothing to do with being abused and being stressed. It countered that nature of the victim as just a compliant person who just was being abused and overwhelmed by a voice.
So could you tell me, I mean, was this somehow put to the expert witness as a way of saying, so if you have this woman striking her son in this fashion, what does that do to your opinion? I mean, I'm still having difficulty understanding how it does anything with respect to the expert's opinion as to the defendant.
Her opinion was based on a particular characterization of both the victim and the defendant. This incident undercut both those characterizations and therefore undercut
Was
the
she
basis
asked
of
about
opinion.
this episode?
She was, well, she was, Your Honor. She was, I believe she was, but more in particular, there was a incident that they were trying to think whether Burgess in particular was asked about this episode at all. But beyond that, she was indeed asked about the fact that despite this characterization of the abusive nature of the victim's relationship with the defendant, that she was asked about the fact that the defendant had in fact denied to DSS any existence of any such relationship. That there was any abuse in the relationship. The expert then tried to explain that by saying that, well, of course she had to say that because that went to her attempts to get the custody of her children back. Again, suggesting that somehow the nature of her relationship with the victim had something to do with the custody issue. Again, opening the door that, wait, no, allowing the prosecution to introduce evidence, wait, no, that custody issue had nothing to do with that relationship. It was solely attributable to actions of the defendant.
I mean, doesn't it matter that it should have been the case that what Dr. Burgess was testifying to wasn't coming in for the truth of the matter anyway?
Your Honor, I think that went to a large degree to the advantage of the defense. It shouldn't have come in substantively. It should have come in for a far more limited purpose.
The prosecution sort of treated it, and you argue it as though, hey, this is substantive evidence. We have every right to fight it as substantive evidence. But
we have every right to fight it as credibility of the opinion evidence as well. So it would have come in even for the limited purpose. What I'm saying, it came in for possible advantage to the defense because it came in substantively. It came in because that history that should have been coming in only in this basis, because it was hearsay to the doctors, that history provides the sole basis for the alleged basis for both the provocation and the self-defense instructions here.
Then we sort of get back to Justice Link's question, don't we? I mean, how much were the experts asked about this? I mean, because that seems to me to be the point of focus, instead of taking on a life of its own.
How much were they asked about? They were asked about it.
I mean, that by the prosecution, sort of questioning about these incidents.
They weren't asked. They were asked about it only insofar as it was in response to the defense question. The judge here was quite clearly had put limits on it in the beginning. Those limits were overstepped by the defense with regularity. Your Honor, for instance, in Burgess, one of the things that the judge had said from the very beginning of her testimony, that when she presented the basis for her opinion, which included reviewing certain particular records, then that would open the door to cross-examining her to anything that is in those records. All of this material was in those records, and all of this material went to the credibility of her opinion for the jury to assess of whether it made sense when it was not consistent with the Burgess's testimony of the victim as the abusive controlling person and for the defendant as such a compliant, acquiescent person. That is just...
And you're saying that those questions were actually asked on cross-examination?
For the first part, in terms of whether the victim was compliant and whether the...
No, I mean, these things that you say were in the medical records, were they used to cross-examine?
Yes, they were. Yes, they were. Absolutely. That was the basis for the ruling that they could be asked of Burgess. Yes, they were. And the foundation was laid. You relied on these things. You relied on this. And aren't you aware that, and isn't it true, that these records say? That was the nature of the approach with Burgess. Absolutely.
Now, if I could turn to the second door. Mr. Shaw says that there really is no dispute anymore that door was barred. Do you agree with that?
Your Honor, the prosecution did not factually challenge that because on the motion for new trial did not agree, has never agreed that the door doesn't work. We did not focus a challenge to the evidence on that because fundamentally approach was even if it true, it didn't matter, and because it didn't go as the judge found, the sitting judge found it, because it would never have had any likely effect on the jury.
Well, you say that, but she was found guilty of first-degree murder, premeditation. If she had an alternative avenue of escape that would have put her into the hallway, as opposed to going past the defendant, doesn't that go to whether she? If she had no alternative but to go past the defendant, then doesn't that go to the issue of whether she premeditated a murder?
Your Honor, this is not a self-defense case.
I know.
It was not presented as
put
a
aside.
self-defense case.
I'm focusing on the issue of premeditation. If she had no choice but to if she thought she had to leave the room and she had no choice, therefore, but to go past the victim, or in the alternative, she had the alternative route to go in the hallway and not encounter the victim, wouldn't that go to what her intent was in leaving the room and potentially to whether she made a decision to kill?
Your Honor, as I said, this is not a self-defense case. This is not the idea that there was an alternative. The defense here was lack of criminal responsibility, that she was so overwhelmed that she couldn't rationally react to the circumstances. And to that, the existence, if you take it that there's no rational ability at that point, because the basis for the lack of criminal responsibility, no ability to control the behavior, then the existence of the second door is essentially immaterial, which is what Burgess said when she was confronted with the possibility, when she admitted that there was indeed a second door, and she said that just goes to show the degree of irrationality of her behavior.
The prosecution was relying on that second door.
No, Your Honor, the prosecution was not particularly relying. You have one sentence in a closing argument, Your Honor. One thing that says, the defense says this was fight or flight. Why didn't they just go out the second door? The primary focus of it's one sentence in a closing argument. The primary focus on here was, throughout the case, was that she was left alone in secure, safe circumstances in the bedroom. Why didn't she stay there? Instead of, as the evidence indicated, coming out of the bedroom saying, "I'm going to kill you," and then immediately killing him. Not that there was no evidence that she was suddenly surprisingly startled by the victim being in the living room, or that she was confronted or assaulted in any way by the victim in the living room. No, the evidence by the eyewitness was that she came straight out there with the knife, with the blade of glass in her hand. She looked left, she looked right. He was off to behind her towards the right. She turned and immediately stabbed him in the chest. Consistent with what she'd just been saying, I'm going to kill you. The door played little or no significance in this case, as found by the judge, who of course was the judge who sat there and heard the entire evidence, who saw it all there, and he's not abusing his discretion by reaching that conclusion that it was going to have no likely effect, because it didn't go to any real live issue in the case, Your Honor.
If I can turn you to the issue of manslaughter and reasonable provocation, should the jury have been instructed that they may consider the entire history of the relationship between the victim and the defendant in evaluating whether or not those circumstances were such as to provoke her?
Well, Your Honor, first, that was never requested here. What we have requested is merely for the judge to say reasonable provocation should be assessed, and how a reasonable person should react in similar circumstances, and then the defense asked for an add-on of in the defendant's shoes. There was no sort of elucidation, as there is on appeal, that this somehow meant that the judge should specifically reference the prior past history. There is none of that.
If it were given, it would change the perspective of the jury as to somebody in her shoes would obviously have known of that history.
No, I think the judge is frankly, Your Honor, I don't see that at all. What I see is similar circumstances in the defendant's shoes, or similar circumstances amounting to effectively the same thing. As the judge saw, no substantive difference, just a difference in wording. That there was no hint here that the jury was somehow precluded from considering that past history as part of the similar circumstances faced by any reasonable person in that particular situation. We have case law in the Commonwealth.
And do I take it from that you concede that the jury should have been permitted or should have considered that history in evaluating reasonable provocation?
I'm saying that they were permitted to do that, and I'm also asking the court to take note that in the Commonwealth the case law is that the judge does not have to go into particular circumstances in particular cases to describe what in fact could amount to adequate provocation, not to describe similar things or give illustrations or talk about examples. It's enough, historically here in the Commonwealth, it's enough to give the general definition of adequate provocation and leave that assessment appropriately to the jury. I think that's quite appropriate, and to suggest that the judge somehow should be required to effectively give an instruction tailored to the particular defense theory of the case is inappropriate.
You wouldn't need to do that. I guess the question is, should the instruction have said something of knowing what the defendant knew, would a reasonable person have been provoked?
Your Honor, I think that that's fairly within what a normal juror could consider as part of the similar circumstances. It's just not precluded. So at the least, I don't think the lengthy, the more focused instruction suggested by the defense on appeal, or that we're talking about now, that its absence didn't create a substantial likelihood of miscarriage of justice in this case. Beyond that, I don't think this is a case that needs to have the court address whether or not in the future, in some other particular case, some kind of more detailed instruction needs to be advanced. I suggest that is essentially inviting the court to emphasize a defense theory of the case. It would be inappropriate, and refer the court to Commonwealth versus Weaver, which which is at 395 Mass 307, which suggests that the judge is not required at all to give particular illustrations of what amount to adequate provocation.
Was a mental impairment, I understand about lack of criminal responsibility, was a mental impairment instruction given? In terms of
I don't
first,
remember, Your Honor, in terms of deliberate premeditation.
Right.
I just don't remember, Your Honor. Your Honor, self-defense, the defense has never seemed to acknowledge that for self-defense instruction to be required, it would have to be some kind of reasonable and actual basis for a apprehension of imminent death or serious bodily injury. Neither one is supported by the evidence here. The experts, it's conceivable that in another case, experts could describe battered women's syndromes in terms of, given a sufficient history of battering of history, that it would be a battered victim could reasonably react this way. No such evidence was presented in this kind of case. There was no suggestion by any of the experts that the victim's reactions were in any way could be viewed as deemed reasonable. No jury could do that unless you virtually eliminate any reasonableness requirement in its entirety.
If I could ask one more question? Not raised in the briefs, and well, let me raise it here. The jury was instructed that they may infer from the use of a dangerous weapon the absence of malice.
The absence of malice, Your Honor?
I'm sorry, the presence. They may infer malice, they may infer malice from the use of a dangerous weapon. Malice means the absence of reasonable provocation. Was it reasonable for the jury to use that instruction to infer the absence of reasonable provocation from the use of the shard here?
Your Honor, the jury was instructed appropriately on provocation that the model instructions include that in the failure to disprove reasonable provocation amounts to a failure to prove malice. It remains true that insofar as malice is concerned, that's true. It's more of a legal. The jury was instructed on the impact of reasonable provocation on malice, and I don't think that undercuts the instruction or is in contrary to the instruction on the reasonable inference that can be drawn by the knowing use of a dangerous weapon, Your Honor.
Thank you, Mr. Townsend.